Hi, I'm Carol Bertsch. I'm a member of the Alamo Caregiver Support Coalition, and I'm here to talk to you today about caregiver superpowers. The job of a caregiver is hard, but there are some tools that will help make it easier, and some of those tools include powers of attorney. There are different kinds of powers of attorney. The first one we're going to talk about is the medical power of attorney. Here in Texas, the medical power of attorney is statutorily promulgated. That means the legislature has set out the form that they want us to use, and we must use a form substantially similar to what they've put out in the legislation. The medical power of attorney covers, as you might expect, all medical decision making. You can limit it to say some things the medical agent can't do, but in general you're going to say the medical agent can make any decision for you that you could have made. By agent, I mean the person who you appoint to handle decisions for you. That's called the agent or the attorney in fact. Your medical agent is going to be someone who can be an advocate for you. You don't want someone who is shy about making your wishes known. You don't want someone who's going to be a wilting violet. No, you want someone who is going to go up to the medical providers and say, my person wants this. This is what my person would want. Now remember, the medical power of attorney only becomes effective upon your incapacity. That means that if your physician has determined that you're unable to understand the nature and consequences of your illness and the pros and cons of treatment options, then your medical agent steps into your place and makes decisions for you. You appoint your medical agent, but the medical agent doesn't do anything until the physician says that you're incapacitated. That's important. Remember that you're the one in control until you become incapacitated. Now, you're always going to name a primary medical agent, an alternate, and even a second alternate, because we never know what's going to happen. Your medical power of attorney, as I said, only becomes effective upon incapacity, and between the time that you do your medical power of attorney and it becomes effective, who knows what might have happened. Your primary agent might have become incapacitated himself or herself, so we have to name an alternate. We have to have backup. The next power of attorney is what I call the financial power of attorney. The financial power of attorney covers everything except health care decisions. So your banking matters, insurance matters, dealing with online assets, dealing with your documents, and financial agent handles all those things. Your power of attorney for finances is also, or there is also, a statutorily promulgated power of attorney for finances. It's called the Statutory Durable Power of Attorney. That means that it stays in effect even if you are incapacitated. That's what durable means. It endures through your incapacity. So you want your financial agent to be the same thing that you want your medical agent. You want a person you want a primary and an alternate and even a second alternate. The skills, though, for your financial agent are different from the skills that your medical agent has. Your financial agent needs to be good with details. They need to be trustworthy, naturally. They need to be someone who can manage your affairs if you become incapacitated. Now, the statutory durable power of attorney allows you to say that your power of attorney becomes effective only upon incapacity, that it springs into effect upon incapacity, just like the medical power of attorney. Or it lets you say that it's effective immediately. As soon as you sign it, then your agent has authority to act. I recommend that you make it effective immediately upon signing. Why is that? Well, one, you want someone who you know is going to act right, whether you're incapacitated or not. And if you're worried that the person who you've appointed might misbehave and take action while you have capacity when they shouldn't, then that's not the right person for us to appoint. If you're worried about that, that's not a trustworthy person. So number one, we want to appoint someone who we know is only going to step into our shoes and take action when it's appropriate. Number two, and this goes to the limitations of powers of attorney. Here in Texas, there's no law that says that third parties have to honor a financial power of attorney. That means that you could have a nice done-up power of attorney done by an attorney, done on 100% cotton paper with a gold medallion raised notary seal. It still can be rejected. Your agent can take it to the bank and say, I need to take action for my principal. That's what you are. You, the person giving power of attorney, are called the principal. Your agent can say, I need to take action, and the bank can say, no, we don't honor powers of attorney. You want the power of attorney to be as appealing to the third party as possible, so you make it effective immediately. That way they don't have to look at the power of attorney and say, well, we don't know if it's effective or not because you haven't brought us any evidence that the person is incapacitated. So if you make your power of attorney springing, it only becomes effective upon incapacity. The bank or third party or insurance company is going to want you to bring some letter from a doctor or some sort of evidence that the person is indeed incapacitated, because you don't have authority to act unless the person is incapacitated. Getting a letter from a doctor that the principal is incapacitated isn't always easy. Some doctors don't want to be involved with that. They don't want to firmly state, yes, this person is incapacitated and can no longer handle their finances. So if you make your power of attorney springing, are giving your agent more trouble. You're making it less convenient and more of a hassle. And remember that the person who you've appointed is taking on a job for your benefit. It's an honor to be appointed as an agent under a power of attorney because it means someone trusts you. But it's not all fun and roses. It's a burden to take that job. So you want to make it as easy as possible for the agent you've appointed. So we've talked about your medical power of attorney and the statutory durable power of attorney or financial power of attorney. You may want to augment the statutory durable power of attorney. For example, it allows certain transactions on its face. There's various transactions authorized in the document. You may want to add to that. For example, you may want to add that transactions regarding digital assets are authorized or that gifting is authorized. One of the limits of the statutory durable power of attorney is that gifts are limited to $14,000 a year, or to the annual exclusion amount, which is $14,000 a year right now. So let's say that you're married and you've appointed your spouse as your agent, and you're going to need to apply for Medicaid to help pay for long-term care. But you've become incapacitated, so your spouse is acting for you. Your spouse is going to need to transfer your assets to herself because you can't have more than $2,000 in countable resources to qualify for Medicaid. To do that, your spouse needs authority under the financial power of attorney to give all of your assets to her. We only have authority to give $14,000 worth of assets in the statutory durable power of attorney. So we're limited. We want instead a broad gifting power that authorizes unlimited gifting to your spouse or to whoever you've appointed, not necessarily your spouse. So The statutory durable power of attorney, while a good start for a financial power of attorney, isn't always sufficient. Sometimes it needs to be augmented. Now, when you're going about augmenting that power of attorney, I really recommend that you see an elder law attorney to do that. You are handling an important legal document, and it's something that has to be done while you have capacity. So you can't give power of attorney to someone to act for you if you are incapacitated yourself. But you're really only going to be using it upon incapacity. So it'll be too late to fix any problems that were created in the document or by the document that you didn't know about. That's why utilizing an attorney, and particularly an elder law attorney, is going to be your best bet. Now, I know this sounds self-serving because I'm an attorney, and here I am saying you should go to an attorney, but I really mean it. I think that it's in your best interest to utilize an attorney for your financial power of attorney. For your medical power of attorney, that's not a complicated document in that there's not a lot of changes we can make to it. It's standardized, and it's what the legislature has said it is. You can get that online. You can get it from texasprobate.com or from the Department of Aging and Disability Services website. And I encourage you to go ahead and get it and do it. Don't put off doing your medical power of attorney because you don't want to go see a lawyer, but definitely do your financial power of attorney with an attorney, with a lawyer. That brings us to, or reminds me to emphasize, you have to do these powers of attorney early. We can't put it off because we never know what's going to happen. And this applies to all of us. Anyone who's over 18 needs to have a medical and a financial power of attorney. We don't know when we're going to get hit by a bus and not be able to make decisions for ourselves. We don't know when we're going to have a massive stroke and be stuck in the hospital, unable to communicate with our loved ones. We don't know when we're going to get dementia and it's going to increase and advance, and soon enough we'll be incapacitated and unable to do the financial power of attorney and the medical power of attorney. These are documents that will really help the persons who have to care for you when that time comes. And you've got to do them early. You've got to do them early. Now, your financial power of attorney, you want to review every 3 to 5 years because you might need to refresh it. You don't want to have a financial power of attorney from 10 years ago that you finally have to use, or your agent finally has to use for you, because third parties like banks or investment companies don't like stale powers of attorney. They like their powers of attorney to be within a recent time period. In fact, some investment companies say that they want a financial power of attorney that has been executed or signed within the last 60 days. Well, this is really not reasonable when you're in a caregiver situation, because you might have done the power of it, or your principal might have done the power of attorney 3 years ago and now has dementia and is incapacitated. They can't do a new power of attorney. So we have to deal with those financial institutions from the standpoint of how can we make them accept what we have, because it's not reasonable, it's not realistic to go back and get a new power of attorney dated within 60 days. If your loved one had capacity to do that, they would have capacity to handle the transaction right now. Sometimes third parties like financial institutions will allow the attorney who drew up the power of attorney to certify that it's still in effect and that the principal had capacity at the time of signing. That's another good reason to utilize a lawyer when you do your financial power of attorney, so that you have that lawyer to go back to if the financial institution is requiring a certification like that. let's talk a little bit about what your duties are as a financial agent or a medical agent. First, under the medical power of attorney, your responsibility is to make the medical decisions that your principal, the person who appointed you, would have wanted. The principal's medical wishes are what guide you. And if you don't know the principal's medical wishes, well, then you're kind of at sea. So the important thing about doing a medical power of attorney is to have a conversation with the person you've appointed so that they are going to know what your values are and what your wishes are in a specific medical situation. Now, the medical situations that can come up are just too numerous and too varied for you to say, okay, if I have a stroke and I haven't improved within 60 days, then I don't want a feeding tube, or I don't want, or various things like that. It's too much. So instead, you want to talk to your agent about what is important to you. For example, is it important to you that you be able to communicate with and recognize your loved ones? Is that a value that's important to you? If so, if you're in a situation where the doctor says, no, you're really not going to improve to the point that you can recognize your loved ones or communicate with them, then your agent is going to know, well, we probably don't want life-sustaining treatment in this kind of circumstance because my principal, the person who appointed me, wouldn't want to continue living in this situation. Okay? So the medical conversation, or the conversation about wishes and values, is just as important as doing the document itself. In fact, in my opinion, it's more important, because if we don't have the document, the law says who we can turn to. But there's no law that says, in case of doubt, take this action. No, the law says do what the principal would have wanted. There are lots of resources out there to help you have those conversations. There's a website called Caring Conversations that you can go to and get suggestions on how to talk with your loved one about what your medical wishes are. And there's lots of other websites out there also. Now, under a financial power of attorney, remember, your duty is scrupulous honesty. You have to act in the principal's best interest, even when that is not in your best interest. Your job as the agent under a financial power of attorney is to do what the principal would have wanted, what the principal would have approved of. But more importantly, it's that you have a high standard of care, that you have a high standard of action with regard to the principal. You have what's called a fiduciary duty to the principal. And that means that you can't act in your own self-interest. You have to act in the principal's best interest. One thing that's troublesome with a financial power of attorney, let's say that you have someone who is definitely incapacitated. They've gotten to the point that they can't live safely at home anymore, but they don't want to leave their home. They want to stay in their home. You have financial power of attorney, and you're making arrangements for them to live somewhere else where they'll be safe, and they don't want to leave. Well, remember I said you're responsible for acting in the way that your principal would approve. In a situation where we're talking about personal safety, though, you do have the right to take action even though your principal, who is incapacitated, doesn't approve of it. It's not something that you should take lightly, because as agent, you want to act in your principal's best interest. But if it's in their best interest to be in a safe place, which is definitely in their best interest, then moving them to a safe place makes sense. We talked a little bit about the limitations, and I want to emphasize that Texas law does not require third parties to honor a financial power of attorney. Now, other states are different. Some states have laws that say that a third party must honor a financial power of attorney. As I said before, we want to make it as easy as possible for the third party to go ahead and honor the financial power of attorney. So we're going to make it immediate. We're not going to make it springing. We're going to name alternate agents, and if an alternate has to serve, we're going to show the third party the reason that the primary can't serve, like a death certificate or a statement by the primary that I decline to serve, or I resign as agent under the power of attorney in favor of this next person who's named. I also want to emphasize that, and I know I'm beating a dead horse here, but you've got to get it early. You can't do it when you're incapacitated. So caregivers, this is something that you need to pressure your loved ones about. They need to do it. If they don't, you're going to be in a world of hurt by the time they're incapacitated. Remember, I said that the medical power of attorney, if we don't have it, the law has a hierarchy for who can make medical decisions without the medical power of attorney. We don't have that same law for a financial power of attorney. So if you need to take financial action for your loved one, and that person is incapacitated and never did a power of attorney, then we're looking at guardianship. We're looking at going to court and saying, Judge, this person lacks capacity and needs to have a guardian appointed. Well, if we're going to court, we're involving lawyers, and we're going to be spending a lot of money. Guardianship is expensive, it's a hassle, it's a burden. Most folks who I know who've done guardianships have really wished they didn't have to do it. They had to do it because of the situation, but they've wished that they had another option, because guardianship is not pleasant. It's not something that you want to go through unless you really have to. And just one more thing, your rights in the financial power of attorney depend on what the document says, and the document controls. So if you don't want your agent to have certain rights, the statutory durable power of attorney has a place where you can cross out, or they have a place where you can initial the rights that you want your agent to have. It's important to notice that the statutory power limits the gifting power, as I said before. So we want to augment that if we want our agent to have unlimited or broad gifting powers. Those are very important. And let me finish up by saying, again, I really want you to do a financial power of attorney with a lawyer. Go ahead and do the medical power of attorney by yourself. That's okay. Remember that a medical power of attorney is different from a living will. Here in Texas, it's two different documents, and you need the medical power of attorney for all medical decisions other than those that regard life-sustaining treatment. Oh, one more thing. If you have documents from another state and you move to Texas, I recommend you go ahead and do Texas documents. It makes it easier for your caregiver in the long run. Even though it's added expense, it makes it easier and simpler, and that's your goal, to make it as easy as possible for you to be cared for when the time comes. On behalf of the Caregiver Support Coalition, I really appreciate your watching today. Thanks a lot.